Good morning. You are Ronald Bratton. And Mr. Bratton, you were previously in court and entered a plea of guilty to failure to comply with sex offender registration requirements. It was an open plea to the court.
We are diving straight into a sentencing hearing that could change everything for Jerry Kyler McGee. He's already pleaded guilty, and now he's staring down a potential 8-year prison sentence. The prosecutor is dead set against probation, and there's a laundry list of other charges looming in the background. McGee is about to take the stand to beg for his freedom, arguing he's a changed man. But is he a victim of circumstance who deserves a second chance, or a master manipulator whose luck has finally run out? Let's find out.
I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Judge.
Are there any additions or corrections?
Not so much, Judge.
All right, Mr. Kelly, you may proceed.
Judge, one of the conversations that Mr. Bratton and I have had over the last couple of weeks, and certainly while this case was pending, is that everything that you've got in front of you was not going to be a surprise. We knew what our background here was. One of the things, two really in this case that I've never seen before. One, you can see Detective Flores' statement here, and while he may not necessarily be advocating for probation, he is at least mentioning it as a possibility, and that's because, as he should be, Mr. Bratton is in compliance right now and has been since after the indictment and after the arrest. The other reason for that is because they have, maybe limited, but they have interactions with each other because he's required to check in with him and stay in touch with him as part of his registration. The other is, and this is from Mr. Bratton's perspective, I've never had someone come to me and ask me to ask the court for safety. I know that it happens, but I'm saying it's never happened to me because it's that rare. And the reason that is one of the things that we're asking the court for today is clearly there are other charges in here where he hasn't registered. It's the same thing we're dealing with now. We understand that. We're kind of owning that as best we're able to right now. But everything that the court's looking at, including the registration issues, it's all drug related. All of it's drug related. While it has an issue, he wants to get serious help, I think for the first time, addressing it. And finally, Judge, we talked about this morning, and I've talked about it over the last week or so, and we don't say it casually, we say it because it's true, because it's coming from him and his experience. It's one thing to be sentenced to TDC, and we're very aware that the court has all the authority to do that today. But the way that he said it to me is, it would be very easy to go do something I've already done and sit and count time. Not that there aren't other things that he can do to improve himself, but sitting and counting time is not hard. Yeah. Doing probation with some pretty serious restrictions on it is hard. It's at least harder than that, as he's conveyed it to me. We have asked while this case has been pending a number of different times, at least 2 or 3, for permission to leave the county to go work for a weekend or work some odd jobs because, frankly, he's scraping it together right now to get to the next day, to try to make a living, to try to improve on some things. We're asking the court for community supervision. We're asking the court if it grants that to add on any conditions that the court believes are necessary. I'd also like a chance to allocute before the court if you'd allow me to.
Go ahead.
Okay, let's break down what just happened. This is huge for the defense. Several charges are being outright dismissed due to missing witnesses or insufficient evidence. The ones that remain are being taken into consideration. In legal terms, this means McGee won't be convicted of these additional crimes, but the judge can still consider the conduct behind them when she decides a sentence. Essentially, his lawyer just cleaned up his record significantly right before sentencing, making the argument for probation a little more palatable. It's a strategic win, but the big question remains. Will it be enough to keep him out of prison?
Go ahead. Oh, I'm sorry. Go ahead, sir.
How you doing today? I'm a little nervous because, I'm sitting in front of the judge. I've been through this since I was 18. Got arrested at 18, indicted at 19, and been going through it. And I've been having that jacket on my back, and also a drug addiction problem. And I've been running like a little boy, just getting by life. Well, since the last time I was at this court, I'm a pawpaw now. And changed me more than even having a kid. You know what I mean? And I'd like to be a better granddad than I was a dad.
Hold on a minute. A bachelor's degree in biology with a double minor in math and chemistry? And he worked in laboratories and medical sales? This is not the background you typically expect to hear in a felony sentencing. This paints a picture of a highly intelligent, educated man with immense potential and a promising career. It creates a powerful narrative for the defense. This string of crimes is a complete aberration, a temporary fall from grace for a man who is otherwise a productive member of society. The contrast is jarring, and you can bet his lawyer is hoping it makes the judge wonder, how on earth did this person end up here?
Mr. Hoffpower.
Your Honor, the state takes judicial notice of the PSI, and also in the indictment, you'll see that this defendant has been convicted 3 prior times for failure to register as a sex offender. That's included in the PSI on page, you'll see on page 4, you'll see that it is Grayson County, Hardin County, 2 other counties where he was given probation and failed and was revoked in Central Penitentiary. And then as well as, this is a problem, obviously, and he's already been to the pen for this. He's been given an opportunity to have probation. He did not complete probation twice. I understand in light of being, those things, but they're always going to be there. And this is a history of not complying with the registration, which he's had that responsibility for a long time. Therefore, we're in here hearing arguments that we hear the first time they do this, not if you'll see there, other times have been dismissed. I'm not even talking about that. I'm talking about the times that he was convicted, and that's 3 from other counties, not Jefferson County. So it's hard for me to take that seriously when it's happened before, and that stuff hasn't changed. Nothing changed within that, and yet here we are again. And through his explanation is that he just decided he didn't want to do it anymore, and he left. Now, whether or not that drug issue, I can't speak to that, but all we know is what we know, and that he has been convicted of this. He knows he needs to do it, yet he fails to do it. And he's going off, and we don't know, and that's the point of having a failure to register, is that we have someone out there who's shown the propensity to act that way and not comply.
Right.
Oh, so
Thank you, Mr. Hoffpower.
And there it is, the classic courtroom explanation. I fell in with the wrong crowd. He says he takes full responsibility. But in the very next breath, he blames the people he was hanging around with. This is a critical moment. Judges have heard this story 1,000 times. While his circumstances, a divorce, unemployment, are certainly tough, the judge has to decide if this is a genuine explanation for a temporary lapse in judgment or if it's just a convenient excuse to deflect personal accountability. What do you think? Is he being sincere, or is this just a performance to avoid prison? Let us know your thoughts down in the comments.
Hoffpower. For some reason, there it is. Used alien. Okay. I have a big question mark on this one, Mr. Bratton, because on paper, you deserve 25 years to life. You're habitual. The fact
Whoa,
that you're
stop the tape. Did he just say, I've never been in trouble in my life? His lawyer literally just asked him about the probation he completed 10 years ago. And we started this hearing with the judge listing off a whole slew of recent charges. This is a massive self-inflicted wound. It makes him look either dishonest or completely oblivious to the gravity of his situation. You can't stand in front of a judge asking for mercy and simultaneously try to erase your entire criminal history with a single unbelievable statement. This is the kind of comment that can destroy a defendant's credibility in an instant.
The fact that your attorney negotiated a plea just to a third-degree felony is already a huge win, in my opinion, because I mean, future behavior is typically, we can tell what you're going to do by what you've been doing in the past a lot of times. People can change, and you've been given so many opportunities. I appreciate Detective Flores's statements. I appreciate the fact that you want help. I don't disagree, honestly, that probation sometimes is harder than prison, especially, I mean, if I give you 10, you're probably not going to do half of that, maybe a third of it, and then we don't have anything. Anything as far as being able to really keep track of you and for a longer period of time. So what I'm going to do today, Mr. Bratton, is give you probably the last chance you're going to get, at least here in this county. All right? So I am going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of failure to comply with sex offender registration requirements. I'm going to sentence you to a term of 10 years in prison, but I'm going to probate that. You will be on probation for 10 years. You will be ordered to enter and successfully complete the SafeP program. You'll go into custody today, you'll wait for a bed, you'll go to SafeP, you'll get out, you'll do whatever aftercare. I would like it probably to be through JCDI unless there's something else. I want it to be intensive outpatient when you get out. You will be given the tools to be successful. It's up to you to take advantage of that. You will be from the beginning on the high medium caseload, and you will be on zero tolerance. That means there is no, I relapsed and I tested positive. There is no, I missed a meeting because I couldn't make it. You make one mistake, I want probation to bring the case back in here, and you're going to go do the 10 years that I just gave you. It's just that simple. This is it. This is your chance. There will be no room for mistakes on this probation because you've already been given that leeway earlier in other cases. So this is it.
And here we go. The judge is stepping in. She heard everything we just heard. The contradictions, the excuses, and the pleas. A judge's questions are never random. They're scalpels designed to cut to the fluff and get to the truth. She's about to zero in on his mindset, and based on her tone, she is not pleased. Defendants often think the hard part is over once the lawyers are done, but an engaged judge can be the toughest questioner in the room. His entire fate now hangs on how he answers these next few questions. This is the moment of truth.
If you do everything you're supposed to and you change your life like you say you want to, that's your choice at this point, right? It's addiction is what it is, but you have the choice now to fight that addiction and to overcome it with the tools we're going to give you. And if you don't, you'll be back in here again looking at the 10 years. If you do it, everything you're supposed to, then you'll be able to serve that 10 years while you're out on probation, and live like the rest of us. Get a real job, be a real dad, be a pawpaw, be all the things you want to be. It's 100% up to you. I will not, you have a 10-year sentence. There will not be negotiations when you come back for some lesser sentence if you violate. That's part of this. You do have rights to appeal that. You pled open. I'm going to hand you the trial court certification that shows you do have some limited rights to appeal. You can talk to Mr. Kelly about that. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Kelly. All right, I wish you the best of the luck, sir. You can go back with the bailiff. Thank you, Mr. Hoppower, Mr. Kelly. I'm going to order a $500 fine as well. Is probation still here on? Yeah. So, Mr. Anderson, you tested positive for marijuana.
It's been 26 days since I last smoked.
What?
It's been 26 days since I last smoked.
Well, it's ridiculous that you're smoking at all. You're on probation. Hold on, don't talk over me right now because things will go much worse than what they're gonna. You're on probation for sexual assault of a child and indecency with a child by sexual contact. You have done nothing that you're supposed to of the things that really concern me with regard to your treatment, your sex offender treatment, all of those kind of things. In addition to that, you're spending your time smoking marijuana. At this time, I'm going to revoke the bonds in each of your cases. There will be no bonds set at this time. I think that is in the best interest of the community and the safety of everyone. We'll get an attorney appointed immediately, and they'll be out to see you, and we can see if there's, I need probably a motion at this time. Okay? You can go back with the bailiff. I'm sorry?
Do I have the time to speak? Can I speak to you about it?
Hold on. Actually, before you do that, he's not on bond.
No.
Okay. So what I'm going to do at this time is I can't do the bond, but I'm putting you in custody. I just got to figure out the right legal way to do it. I'm going to find at this time, as a condition of your probation, that you serve at least 20 days. That'll give everyone time to get everything taken care of, so that we can move forward and see what the appropriate way is. So I'm ordering 20 days as a condition of your probation, starting today, no credit for any time, and then we'll see where we get. All right, go back with the bailiff.
No, I can type it today and
Okay.
send it over to them.
Perfect, thank you.
What a powerful ending. The judge completely dismantled his argument with one simple question about the word deserve. She pointed out that probation isn't something a defendant is owed. It's a privilege. She reminded him that the community deserves to be safe from crime. In that single exchange, she exposed a sense of entitlement and shifted the focus back to his accountability. We don't see the final ruling, but that correction was a masterclass in judicial authority. Jerry McGee came in with a story of a highly educated man who made a few mistakes, but his own testimony, filled with contradictions and misplaced confidence, may have been his undoing. The judge's final words leave little doubt. She was not impressed. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.